Thank you for tuning in to the Brach Eichler Talks podcast, where we explore and discuss today's trending legal topics. In this episode, we'll discuss a recent labor and employment law alert titled the FMLA In Focus, recently issued guidance about calculating leave entitlements for intermittent and reduced schedule leaves. A recently issued opinion letter from the U.S. Department of Labor, DOL, explains how an employer should convert an employee's weeks of available leave under the Family Medical Leave Act, FMLA, into hours. The guidance applies when an employee uses FMLA in less than full week increments, such as during intermittent or reduced schedule leave. Eligible employees are entitled to up to 12 weeks of leave under the FMLA during the relevant 12-month lookback period. However, when an employee takes intermittent or reduced schedule leave, an employer must determine the employee's hourly leave entitlement. While employers may assume that an employee who works a regular 40-hour workweek with no overtime is entitled to 480 hours of leave, how many hours of leave an employee is entitled to becomes more complicated when the employee works a variable schedule. The DOL's recent opinion letter discusses how to convert an employee's 12-week leave entitlement into hours of leave for purposes of intermittent or reduced schedule leave. The DOL clarifies that an employee's hourly leave entitlement should reflect the employee's actual, regularly scheduled work week. For example, if an employee works 30 hours each week, the employee would be entitled to 360 hours of leave. In order to determine the hourly leave entitlement for employees who work a variable work schedule, an employer must calculate the employee's average weekly hours worked. The average should be based upon the weekly hours worked during the 12 months before the anticipated start of leave. If an employee is regularly scheduled to work mandatory overtime, those hours should be included in the calculation of available leave hours, according to the DOL. However, additional hours of voluntary work should not be included. A similar approach should be taken when determining how much leave the employee has used. If the employee regularly works mandatory overtime, and that overtime is missed because the employee is on leave, that time should be both included in the employee's hours of FMLA entitlement and deducted from the employee's total available leave. This was the approach upheld in Hernandez v. Bridgestone Americas Tire Operations LLC, 831F through 940 8th Sir 2016. Converting FMLA weeks to hours, both for purposes of entitlement and usage, can also arise when an employee's work schedule changes, either prior to or during leave, such as a change from part-time to full-time or vice versa. Given the intricacies of FMLA, employers should carefully review their FMLA policies and procedures to ensure compliance with the clarified calculation method. Available hours should also be entered in Section 3 of the FMLA designation notice whenever leave is approved. For more information about how your organization can properly manage FMLA compliance, please contact J. Sabin, Esquire, Member, Labor and Employment Practice at 917-596-8987 or jsabin@bracheichler.com or Sarah A. Gober, Esquire, Counsel, Labor and Employment Practice at 973-364-8375 or sgober@bracheichler.com. Don't forget to subscribe to our podcast on Spotify, Apple Podcasts, and YouTube. Follow us on LinkedIn and Facebook for updates on new episodes. For more information and resources, visit bracheichler.com. This is intended to provide general information, not legal advice. Please contact the authors if you need specific legal advice. Brach Eichler LLC is a full-service law firm based in Roseland, New Jersey with over 80 attorneys. The firm is focused on the following practice areas: healthcare law, real estate, litigation, trusts and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property, and information technology, real estate tax appeals, tax and cannabis law.